Hey everyone, this is attorney Andre. Now, in my years of practice, and now that I have a YouTube channel, and since I'm actively on Instagram and I'm actively on Twitter and actively on TikTok, I'm getting so many inquiries from a whole bunch of you. And a lot of you keep asking the same questions, so I want to kind of like to make a question and answer session about this and kind of give you an answer to the most asked questions. So, the first question that I get is, what's the most important thing you need to know to start a business? Well, the most important thing you need to know to start a business, it's super important. It's your cost per client acquisition. How much is it going to cost you to get that client in the door? What's your advertising budget? Really, the industries that have the biggest, I guess, bang for your buck are the same industries that have the most cost per client acquisition. So, personal injury attorneys, real estate agents, commercial real estate agents, people that work in the insurance industry, people that work in car sales, sometimes solar panel sales, something like that. Things that really have a high cost per client acquisition. So how much money are you spending to get not one lead, but to get one client? Because you can spend very little to get a lead. I mean, you can spend like $20 to get a lead, but that doesn't mean that that lead will turn into a client, and that client will sign the contract, and that contract will bring you money. So very important, lesson number one, figure out your cost per client acquisition. Because a lot of the time, you're going to have your original cost, and then it's going to bring in, I don't know, a couple thousand leads, and out of those couple thousand leads, you'll have maybe one or two contracts that are signed, and you'll make money off of those one or two contracts. So the first step, and the most important, is forget a business plan, forget a location, forget all of that stuff. That's all fine and good. But what you really need to know if you want to start your business, what really is going to determine the success of your business, is the cost per client acquisition. That's the first thing, most important thing about starting a business. Number two, what's the most important term that I should have in my partnership agreement if I'm a serial entrepreneur? So a lot of us, like me in particular, I have one business, I have another business, I have clients that have multiple businesses, 10 businesses, because what a lot of people tell you is that you should have multiple streams of income. And if you're going to have multiple streams of income and multiple LLCs or multiple corporate entities, you want to make sure that those entities don't conflict with one another. So it's very important to do two things. If you're a serial entrepreneur, have a disclosure somewhere that says, look, I'm involved in all of these other businesses that may or may not be competing. And if I'm involved in those businesses, or if I take time away from running this business to run my other businesses, it's not a breach of fiduciary duty. And here is why. Because in every single business, with your partnership, with your shareholders, with everyone, you have a fiduciary duty. And that means you have a duty of the utmost care and loyalty to your business. You're supposed to do everything you possibly could to make that business survive. But if you're in business A and you're in business B, and I'm not even saying they compete with one another, but if you're in business A and you're in business B, and you're spending some weeks 50 hours on business B and only 10 hours on business A, well, then the partner who is maybe not happy that you're making so much money off of business B can say, look, you're not fulfilling your duty in the business, you're not doing your job, you've breached your fiduciary duty, and boom, all of a sudden, you've got a conflict. So you want to make sure in those partnership agreements, especially if you're a serial entrepreneur, that you make sure you delineate what your duties are, and you making sure that if you focus on other businesses, it's not going to be a breach of fiduciary duty. I did that when I ran multiple law firms. So I had like 2 or 3 law firms that I was running. Then I was in venture capitalism. Then I was doing a couple of other things like investing on the side here and there, doing real estate transactions, and all of that. I needed to make sure that all of my other partners understood that my actions in this other business, in this other firm, in this other entity is totally separate and is not a breach of fiduciary duty. It's the same thing that I have now. I own a law firm. I own the Traber Reichelson Law Group. I also have my own law firm, the Law Offices of Andre Reichelson. And I also do YouTube where I promote myself. I make it very clear that when I'm promoting myself, even if it takes away business from Traber Reichelson, even if it takes away business from Reichelson Law, or even if it takes away business from anything else that I'm doing, it's not considered a breach of fiduciary duty because I'm not actively promoting, siphoning away clients. Now, if I were to say, don't go to Traber Reichelson Law, go to me individually, or go to this other law firm that I'm a part of, go to this other entity that I'm a part of, then it could be an issue. But unless something like that actively happens, I make very clear and very sure that my actions doing this for you guys on YouTube doesn't conflict and is not a breach of my fiduciary duty on my other stuff. Number 3, can I raise money from my project for the general public? And this is very important. Can you raise money from the general public if you have a project like crowdfunding or crowdsourcing or something like that? And the reality is, if you look at it strictly legally, you can't. The reality is that if you raise money from the general public, and I'm not talking about friends and family, but you like put a crowdsourcing page up there, you're putting flyers up saying, look, invest money into my new venture, then it's still considered a security. It still has to be registered with the SEC. There's multiple exceptions, but there's one main exception, and that's Rule 506D of Regulation D, and that's a safe harbor provision. If you're interested in learning more about that, I can talk more about that, but it's essentially an exception to registration. And when you do that, you have to file with the SEC. It's through a database called Edgar, and you file what's called a PPM, a private placement memorandum. If any of you watch Meet Kevin, for example, he has a program called House Hack, and he has a private placement memorandum. He is registered through Regulation D of 5, I believe it's 506. There might be another one that he's also registered in. But for those kinds of investment vehicles, you issue a private placement memorandum. You have a delineation between institutional investors and non-institutional investors. You have accreditation. You have a delineation between accredited investors, which are usually institutional investors, but they might not be institutional investors, and non-accredited investors. And you have to know the difference between a non-accredited investor and an accredited investor, and how many accredited investors can you have compared to how many non-accredited investors you have. So all of those things are really, really important. A lot of people, they have a project, they don't know this law, and they just do like a crowdsourcing page or a crowdfunding page. And then sometimes if it gets big enough, if it catches the eye of somebody, they can get into a lot of trouble because they didn't do the proper private placement memorandum. They didn't do the proper protocol. And I've actually sued companies and won companies on behalf of shareholders where we were saying, look, where is your PPM? Where is your data? How do you know that my client is an accredited investor? How do you know that that's even my client's money? You don't know any of that. So those are things that really you need to consider. And those are things, by the way, that anyone can sue you on, not just the government, because in the rule, there's a private cause of action. What's a private cause of action? Well, a public cause of action is a cause of action where the government can come after you. A private cause of action is where anyone else can come after you if they want to file a lawsuit. So that's really important to know, that there's a private cause of action. If you want to issue some crowdfunding, or if you want to raise shares, if you want to raise money, then you have to do it through the proper vehicle. The next thing is, should I open up a revocable trust to protect my assets? And this really depends on what you want to protect and what kind of assets you have. If all you have is just a huge bank account with $30 million, then, and you have a spouse that does nothing but sits at home, then you could just and you live in Florida or another homestead state, then you can just put all of that money in a joint account and it's protected from creditors. You can also set up an LLC. You can set up a trust, but if it's a revocable trust, it has less protections than an irrevocable trust. So there are many differences between a revocable and irrevocable trust. An irrevocable trust gives control to someone else, whereas a revocable trust, obviously you can revoke, so it has substantially less protections. A lot of times people purchase homes in a trust, people keep jewelry in the trust. They can do that as opposed to an LLC. And at least in Florida, you get the same homestead protection in a trust that you would get individually that you wouldn't get in an LLC. And a lot of homestead states have something similar to that. So in those certain circumstances, there are about like 15 or 20 different circumstances where a trust is better than a company. A trust is better than an LLC or a corporation, where a trust can help you. And there are certain situations where a trust is not needed. A lot of people have a trust that owns an entity that is a Cayman Islands entity that has different shell companies or shelf companies in Wisconsin and that do business in Delaware, and they have this whole web. Frankly, to be honest with you, that's super unnecessary. Anyone that's really advocating for that is really trying to take your money. That is so unnecessary because it doesn't give you any more protection, and it doesn't give you any more protection for figuring out who you are. I mean, if I were to sue that let's say that tentacle, the Wisconsin Shell Company, but you've got all your money stored in the Cayman Islands in the main trust. It's a Cayman Islands trust. Then all I have to do in discovery is say, hey, who's your parent company? Where is that located? And now I know that the parent company is a revocable trust that's tied to the Cayman Islands. And then I can do whatever I want to do from there. You can object to me doing that, but then you're just going to have to go to the court, and then you can win your objection or lose your objection. But if you lose your objection, then I've got access to all of that stuff. So you're not really protecting anyone. And to the extent that someone can collect your assets or not collect your assets, that's true. You can collecting assets is substantially difficult if you have multiple tentacles, but it can be just as difficult if you have one or two tentacles, if you do it the right way, instead of opening up some kind of crazy elaborate scheme. Because I got to tell you, I represent some of the wealthiest people, and a lot of them don't have this crazy elaborate scheme. Sometimes it's just not worth it. The managing of that whole structure is more complicated and more costly than doing a simplified version and then having layers of insurance or umbrella insurance to cover you for anything that can possibly happen. Like, a lot of big companies have insurance on their board of directors, and then they'll have umbrella insurances for other things, and then they'll have their home in a trust, they'll have their bank account in joint spouses or in some kind of LLC or some kind of holding company, and then that holding company would hold multiple other assets, but they wouldn't have some kind of crazy structure where you have trust upon trust upon trust, where each trust holds absolutely nothing, and then you have the ultimate entity that holds one thing, and that's controlled by two separate trusts, or one of them managed by an LLC and one of them managed by an irrevocable trust that's not really irrevocable. So you have situations like that where you have a crazy situation where it's so difficult to maintain, and it's not really worth it. So what's the last thing that people always ask me? The last thing that people ask me is, an LLC better than a corporation? When is an LLC better? When is a corporation better? How about if I open up an S Corp? How about if I open up a C Corp? First of all, let me just throw that notion out there. There is no such thing as different kinds of corporations. You have a for-profit corporation and you have a non-profit corporation, and the distinction between C and S Corp is really just how you're taxed. So an S Corp and a C Corp is taxed differently. One has pass-through taxation, the other one doesn't have pass-through taxation. It matters how many employees you have, but they're not different types of corporations, they're different types of tax structures. Corporations are better if you have a huge entity with multiple tiers of shareholders, with multiple kinds of staggered shares, if you have poison pills to protect it from corporate raiders. If you're in that kind of position, then yeah, a corporation is so much better. A corporation also kind of helps you find a domicile in one particular place, plus your quote-unquote headquarters for litigation purposes, but that might not be best. An LLC is great for simplicity, whereas a corporation needs bylaws and certificates of corporation and annual meetings and shareholder meetings and things like that. An LLC is much easier. It gives you the same protection as a corporation legally, plus one more thing. An LLC is a disjointed entity. So the place where the LLC is, for federal court purposes, is where all of the members are. So that means that it's really difficult, especially with a very big LLC, it's really difficult to get diversity. And a lot of times you're being sued locally in state courts, unless your whole goal is to be sued in federal court, in which case a corporation is probably the better vehicle for you. But the reality is that if you want to get cases kicked out of federal court and you've got a lot of members, an LLC is good for you. An LLC is not good for staggered shares. An LLC is not good for different kinds of corporate poison pills. You can implement that into the operating agreement, but it makes things difficult, much more difficult than when you have a corporation with a particular share ledger. And again, certain states require a share ledger, certain states don't require a share ledger. But if you were starting out your own business, I would start out with an LLC. I wouldn't start that as a corporation unless you have an investor or a silent partner or something like that. Then I would start out as a corporation. But you need to make sure you keep all of the corporate formalities, because if you don't and someone sues you, they can disregard or pierce the corporate veil and go right to you, and that would suck, because now they've got access to all of your assets. And unless you have that crazy system we were talking about, then that might be a bit of an issue. And for those that say it might not be an issue, remember one thing, that if you hide your assets or transfer assets in the middle of litigation, somebody can sue you for a fraudulent transfer, claw those assets back, or simply file what's called proceedings supplementary, bring third parties in to cover your debts. And if they know how to do it well, because I've done it before, if they know how to do it well, then it's a big problem. But anyways, let me know what you think. Do you have these same questions? Did any of these answers to these questions help you? Let me know if you have any questions for me. I'm happy to answer them. Talk to you later. Like, comment, subscribe. See you soon. Bye.